Okay. Hey, you guys. I was awaiting StreamYard to throw up the numbers there. Welcome in, everyone. Good evening, good evening, good evening. Are you guys freezing your doohickeys off? I'm so cold. I've got two heaters running. Cass. Hello, my love. Long time no see. Hey, Patty. Hey, Mama. How are you? Where'd B Blanco go? He was here a few minutes ago. Okay, so as you guys know, most of you know, we're starting from scratch on this channel. We got to rewind 2 years to catch up on this case and move ourselves forward so that we know exactly what's going on here, right? So I am today we watched a portion. Well, we watched one of the hearings that occurred in December of 2024 in regards to the prosecution trying to get some information that I'm sorry, the defense trying to get some documents that they call are private and work product from being put out in the public. And we watched that today because she was supposed to be in court this morning. And I went on the docket again this afternoon. They've moved it to January the 21st. So they were not in court today. And when they do go back to court, we will be there waiting just like we were today to see what we can find. Okay. So just know that. One thing I was doing today, like after that, hey, Dread, good to see everybody. Welcome in, you guys. After that occurred today, after we watched that, I was going through and looking at trying to find some more of my research stuff because I was putting different pieces together. And I came across a documentary that was put up on Fox, and it was done by TMZ. And this was done prior to the parents being arrested in 20. Wait, were they arrested in 2024? Yeah, so it was prior to their arrest. So it was a TMZ investigates little documentary. Did you guys see it? Well, the mom and dad were in there on there for an interview, and of course they were talking about how their sweet baby and how good she is, and what a loyal person, trusting and everything. And okay, I get it. It's their daughter. I get that. That's fine. So I kind of wanted to go over the documentary with you guys a little bit before we listen to today's hearing or listen to this hearing from 2 years ago. So in this documentary, you see the mom and dad do their little spiel, right? And then the judge is brought up there. The judge does mention somewhere, I don't know if it's in this video or it might be in 2024. She mentions the fact that the defense is going on, or that the parents have been part of a documentary on the case, which I thought was interesting. Uh, this on this documentary, Christian's family did not participate in it. They did play some clips from him, but he did not participate. And her attorney was criticizing the press release from the prosecution. And I want to go back and watch that. And that might be something we do after watching this hearing. And it was where they first initially did her charges, where they announced what they were charging her for, and so on and so forth. So they were just saying that it was like a witch hunt type thing. But one thing I found out in this interview or in this series that I was not aware of, I guess I missed it somewhere down the road, is that Courtney Clenney, when she lived in Austin, and I do believe this is after she met Christian, she worked at a strip club. And I thought that was interesting because, that was the time period after LA, before Miami. So she'd been doing Instagram. She'd been doing branding, products, and all that. So I just thought it was interesting that she was a stripper. And the fact that I'm sure if some of these products found out that she was doing all that in her time off of the internet, they probably would not have been wanting her to do their products. That's just, that's the way it works. Anyway, it shows content from their Aspen trip, and they did several OnlyFans collaboration trips. Basically, what these collab trips were And what I'm researching, they went to Aspen, they went to Palm Beach, a couple of different places they went. They would all get together and film. And it was couples, and it was a lot of women, and it was all OnlyFans women. So if that tells you anything, they would get together and record. And I'll go into more of that in another video. What was the other thing I wanted to talk to you guys about? That was done in February of 2022 when they went on the Aspen trip. Now there was another OnlyFans model that actually spoke in. There was actually two of them that spoke in this documentary, and one of them said that Christian was almost pushing. He was so freely offering Courtney drugs that it was like he was almost like he was pushing them on her. This is what she claims. Another one said that she could just tell that their relationship was toxic and that Courtney was the aggressor. So I don't know if Christian had a substance abuse problem either. He could have, you guys. This is not something we need to brush over. If they both had it, it could say a lot about the way they were both acting. It could say a lot about why he was putting up with her. You know, we talked about money and all that, and we talked about the fact that he claims he loves her and all that. But what if he was so into her that he knew she was feeding his addiction, you know? I don't know. I just want to throw that out there. There was a lot of fighting going on in the Austin, Texas apartment, and they actually interviewed a neighbor that lived below them. I don't know if it was a floor or two below. He said they were so loud that they ended up all calling the police several times. He also said that after Courtney had moved out of that apartment in Austin, she'd only lived there for like maybe a year. It wasn't that long. I think he lived with her part of the time. I don't know if he lived with her the whole time she was there, but he said that unit was so trashed after Courtney moved out that they had to do like a 2-week renovation. The apartment complex did to get that unit ready to be leased out to someone new. So I thought that was really interesting. Now, going back to what these OnlyFans models were saying and stuff about the two of them, I want to make it clear that when we see any kind of OnlyFans models up there being interviewed, I don't want it to be lost that anytime they can get in front of a camera and get publicity, it helps them, right? It helps their channels, it helps their pages. So I want to be really careful and like take all of what they say with a grain of salt, just because, yeah, they were there, they saw it all, but I don't know. Are they doing it for the right reasons? Are they talking to the media for the right reasons? And I guess that would be my question in it. Now, Courtney was also charged in Vegas for that altercation, and Christian was not arrested. And we're going to go back and watch all of that. We're going to do a piece on the Vegas thing. Okay. So be prepared for that. They also show some very sad pictures of Christian's face being that where it was cut. And I believe this was in February of 2022. It was prior to the elevator incident. I don't know if it was cut with, it could be glass if she threw glass at him. It could be her nails. The cut on the front of his chin looked pretty clean. Like it had to have been done with it just seemed like glass or a weapon. I don't know. So they show some of those photos, and they go into the fact that in March of 2022, mom comes for a visit because Courtney tells mom that she wants to kick Christian out of the apartment, but she needs mom there for support and to help her do this. Now, I feel like if they were frightful of Christian being aggressive, and I think could be a point that could be brought up by prosecution. If you're so scared of him as a physical threat to you, then I think you would want your dad there as well. You would want a man there too, not just your mom helping you get him out. Because, moms, they're there more for moral support. That's just my thought on that. On April 2nd is when mom leaves. And that is the point when Christian, they had been broken up. Christian's in the lobby loitering. The security camp calls police. Police come out. We've got that body cam. We're going to look at those pieces. And then prior to, I guess it was a few days before Christian's death, one of the Miami residents from the neighboring building, and we have this on body cam, and I saw it. He spoke to, he was interviewed. I think his name is Arthur. He was interviewed in this documentary series. He lived in a neighboring building. And if you guys remember, TMZ was they had some footage on her building right after the incident occurred, because the buildings are so close together that you can see. You could spy on each other if you wanted to. So this neighbor says that there was an incident where he saw that Courtney was up against a wall, and he's looking out his window. He's looking into their unit, and he can see Christian abuse her, go after her physically. He said, I saw it, and then I saw Christian come towards the window at some point. When Christian noticed that I was watching, so that they must be close enough to where they could see that, he said Christian pulls the blinds down. He's going to probably be called as a witness. It'll be interesting to hear what he has to say. So mom says in this documentary that Christian almost unalived his daughter. And that had Christian not passed that evening, that Courtney would have been the one that passed. She was saying that the elevator was Courtney trying to keep, that when the elevator thing happened, that Courtney was trying to push him out of the elevator and try to keep him from coming into her unit. That's a whole nother video I want to get into with you guys, because I have some speculation about that as well. Mom was adamant. I mean, she basically said that, I guess it came up more than once because I wrote it down twice, that Courtney her life was in danger at that point. If her life was in danger, then why didn't they call the police? Why is everybody else calling the police except for Courtney? Now, the topic of the weapon being thrown or versus stabbing was also brought up, and my thought on this is it's almost like a red herring. It's like the defense is Courtney said this in her interview, that she threw the knife, that she didn't stab him. So the defense has to work with that, right? They have to prove that it was self-defense, and because I feel like either way, it could be self-defense, whether she threw it or she stabbed. To me, it doesn't matter either way. It was either self-defense or it wasn't self-defense. And that is the piece that I want to say, this whole, them bringing the pig into play, where they're doing this professional knife thrower. They have a pig carcass, and they're throwing the knife at the pig carcass. Ugh. God forbid if PETA gets involved in this. It's going to be a nightmare. But they're trying to demonstrate if those kitchen knives could actually hold into a body. So that was what's that all. We're going to watch these are going to come up, and this actually comes up. It may not be in what we watch tonight, but that we are going to watch some of that video. And then also mom said that her using the racial slur against Christian was more about her trying to get him to go away. Like, she wanted to upset him. She wanted to offend him. She wanted him to feel bad. So her doing that was done on purpose, the mom says. Daddy also says that he continues to call Courtney in his documentary his little girl several times. His little girl, his little girl. And at one point he calls her their baby, their baby. He talks about how mentally strong she is and how proud he is of her, how strong she is. Okay, baby was doing some bad things on the internet and getting paid because men were watching. Okay, daddy. So let's just Be cautious in your words, Dad. I guess this way I feel it's kind of creepy to me. It's just I know that's her father, but it just I just feel like he had to have known you guys. If your child lives in another state, you want to follow what's going on with their lives. If they've got an Instagram account, especially if they're making money off of doing Instagram, you want to follow their work. You want to see what they're doing. You want to see what's going on in their lives, and that's probably the easiest way to do it other than talk to them on the phone regularly, right? So you go in and you follow their Instagram page. So many videos she did on Instagram, she says, check out the link in my bio. Check out the link in my bio. And again, the link in the bio, where does it go? It goes to OnlyFans. Now, whether or not the parents didn't have a OnlyFans account for her or didn't pay to see what was going on in there, maybe they didn't. Maybe they thought it was just them doing, I would say, talking about things they couldn't talk about, like maybe stuff that wasn't that bad, but it was just like kind of X-rated, lower X-rated type stuff. I don't know what they thought, but it's like, how do you not know she was on OnlyFans doing that stuff? I'm sorry. I have to just get on my soapbox on that one because it's kind of driving me crazy. First of all, Mama knows. Mama always knows, you guys. If Daddy don't know, Mama knows. And if Daddy didn't know, Mama was covering for baby. Okay. Ugh. So anyway, I did also, and I saw this later on. It came up twice today. I can't believe I missed this. Earlier today, I mentioned the fact that I said I'd put money on the fact that the Obumseli family is going to file a lawsuit against the complex, and they have. They actually already did. They've got a civil lawsuit against the condo complex, the security firm that worked there, which the security firm worked for First Residential. First Residential is a community association property management company who employs their own security staff. Pretty certain it's the same entity for their security as it is for their managers. And then, of course, also they've got Courtney named in that lawsuit as well. So, I mean, that was bound to happen. That doesn't surprise me. And there was one other thing I wanted to correct that I put in one of my first videos, that her rent was $1,200 a month in Miami. I was incorrect, and someone did correct me. It's not $1,200 a month. It was $1,000 or $1,100. I'm sorry. It was $1,000. Never mind. Just stop, Kerry. It was $10,000 a month. $10,000 a month, not $12,000. Okay. So we got that corrected. Okay, so let's watch this. Let's watch this court feed now. Now, I will tell you guys before I start it, it's a little wobbly in the beginning. It does get better, but what I did was I went in and I put the captures on large so that we don't miss anything. So we might have to read a little bit at first, but I know at least 20 minutes into the video, it gets a lot better. So let's get to it.
I was gonna have a copy for you.
November of 2022.
You see, I'm good. I know, but I'm good, sir.
This is kind of one of the first hearings they had next to her bond hearing. I think her bond hearing was a different date. It was on December the 8th of 2022. So this is kind of they're presenting the evidence to the judge in this particular
they're coming.
hearing. And it did last 2 days.
I mean,
and today, the hearing that we're watching now, it was over 4 hours long. So we're going to watch the first portion now, and then we'll watch another portion of it probably Thursday night. We'll pick back up. Yeah, the charges against the parents and Courtney have been dropped for the unauthorized access of documents. Or I guess of electronic equipment. It was electronic equipment.
Kerry, you have an extra thing to say?
I wonder if she's gaining weight in jail, you guys, because she looks a little. Of course, this was just right after she'd gone in, but I bet she's going to end up gaining some weight because she can't work out the way she was before. She can't get the exercise she was getting. And no more drugs.
Is that on you? You want me to do it as a composite or just one? Of course you can.
Let me fast forward through this.
Sean,
See, it's even like, here it is.
Sean.
Yes, Judge. And for the record, Sean Abduhoff, Khalil Quinnen, and Kathleen Hogue on behalf of the state.
Good afternoon, Your Honor. Larry Hanford on behalf of the Pacello family representing the victim.
Good afternoon, Judge. Frank Diaz on behalf of Courtney Clenney, as well as my co-counsel Sabrina Puglisi.
Welcome, everybody. And I know that there are probably family members who are out in the audience as well. So I know that this is probably an emotional day for everybody. A reminder that if you feel the need to step out, that's absolutely fine. If you need anything from my bailiff, his name is Ali, he can help you. Reminder to just remain respectful and courteous and quiet. So let's go ahead and get started. Court versus Clenney. So I think we're going to go into the initial statements first.
Sure. First and foremost, the defendant's argument to preclude the state from using the recorded statements, frankly, for the purposes of this setting at least, is untimely. It is a substantive motion as outlined by the case law. It requires competent substantial evidence, for which the burden is on the defendant. Before the court, there isn't any, not even an affidavit to submit to the court. So the defendant would be unable to support its burden under the case law to meet the two-pronged test that I outlined previously to the court. Furthermore, as it pertains to that issue, there are 4 videos. I'm just going to mention the videos because I don't have them off the top of my head. I have to stop my argument to go mention them. The first video is in the lobby of a building in public, clear as day. I mean, the defense can't even on its face make an argument for that, assuming that they somehow meet the two-pronged test. The second aspect as it pertains to the three following recordings, frankly, defense is their point. It is a recording by security from the outside of the building.
Really quickly, when we saw you right there, or that I watched, I didn't see a video portion to any of them under
Number 1.
my computer just played the audio. So again, it's available, but I was able to bypass this time for the audio, so I didn't see a video of your attention from the audio.
Sure. Again, I can. That one is, and counsel can agree with me or agree with me as to my recommendation. The lobby of the building. It shows Ms. Clenney with a dog walking up and sitting down. Mr. Sally is reporting him up for a while. It records Ms. Clenney's chest, and they have a conversation between them. and Ms. Clenney or Mr. Buselli says it does something to the effect that it's not ready to pick me, and she then whispers in response some expletives. That all happened in the lobby of the building. There's no expectation of privacy there, period, bar none. So the defense would be impossible for the defense to show an expectation of privacy as it pertains to that. The three remaining ones, I would agree that they occurred in their apartment. Very brief snippets. You can see the apartment from the inside, either the TV or the clothing on the floor or something to that effect. So I don't disagree with that. And assuming the defense is able to make their showing of two-pronged test, they would fail on the reasonable expectation of privacy. Explicitly, actually, their defense exhibit G, which while they characterize it as, quote, audio surveillance, I have for the court the incident report from the building that day, February 26, 2022, where the security guard said she recorded the woman's voice. It's the last sentence from that. So it's a recording from the outside of the apartment. So certainly a recording from the outside of the apartment is different than a recording from the inside of the apartment. But the point is that if it's audible from the outside of the apartment, she does not have a reasonable expectation of privacy. And the very nature of her shouting and the building sending her emails about the arguments, police responding unqualified her or anybody else because of the arguments, necessarily relates that a reasonable person shouting at the top of their lungs can expect that their neighbors will hear it and possibly record it. The fact that Christian recorded it is of no consequence. Whether she consented to it is of no consequence because
Specifically asked in video number 3.
3, 5, if I'm not mistaken, it's items 3, 5, and 7, because I believe the videos are odd numbers and the metadata are the even numbers on exhibit 11.
Judge, with respect to the lobby video, we don't have an objection.
Do you guys see do you pick up on what they're saying about the whole privacy thing? Like if she's yelling at the top of her lungs so loud that everybody can hear her all throughout the building, well, not throughout the building, but around her unit, then you lose the expectation of privacy. Makes sense, I guess.
That, but it's clear that there is no video. Your Honor's correct. There's no video on those other recordings because the recording device, which is the phone, is secreted on his person. So that's why there is no video, because it's on his person. With respect to the state's argument about the security could hear outside, that's a separate incident. That is not the day of these recordings. And this apartment, and this actually comes is of import later on in our presentation. This apartment had an elevator that goes directly into the apartment. It's basically its own floor, own entrance. This is not an apartment building that has multiple units separated by thin drywall. Okay, this apartment had its own floor, and the state cannot dispute that. The state also cannot dispute that this was a surreptitious recording, secreted on his person. Therefore, it's a clear violation of 934. It's an illegal wiretap. This is a two-party state. And the only thing the defense has to show is that there's an expectation of privacy and that society is willing to accept that. And that's in Canario, I think it's in Canario, I can't pronounce it, in Serrano, Seaver's in Serrano, which is 473 Southern 2nd, 1272. And that is a Supreme Court case from 85. That case talks about, is there a reasonable expectation of privacy for the oral communication, which clearly it's an oral communication, and whether or not society is willing to accept it. What more would society be willing to accept than somebody, whether they're raising their voice, yelling, screaming, than their own apartment? That is clearly, we've met the burden and the standards that's elicited or is laid out in State versus Incarnati. Further, Judge, the recording, the big difference between the recording that the defense submitted to you with, I think it was G, is a recording by a security guard from the One Parole building. Pursuant to her job duties, she is investigating a disturbance. Anything she records during her duties is something that it would be, number one, it's not going to be hearsay because it would be a business record, right? Kept in the regular course of business. And so I don't even, Again, hearsay could be admissible in this type of hearing, so I won't even address that. But what is different is that was a call to security for a disturbance. Normally, there would not be anybody outside her door. There wouldn't be. So the reasonable expectation of privacy that Ms. Clenney had is obvious. And I think it's an expectation of privacy that society is clearly willing to accept in one's own apartment under the circumstances of this particular case.
So let me say this, first of all, we want to deny your request for not having this, as a hearing, because it's untimely. We want to go ahead and allow arguments to go forward so that I can make a ruling as to whether or not these recordings are going to be in evidence for the purposes of this hearing only. I think that you can make arguments both ways, as to both the defense's, allegations as well as the state. So I'm going to go ahead and hear arguments and make a little comment. Second, the recording that is taken by the security officer at the apartment building, are you both agreeing that that is a recording of the same incident that is being played under?
No, that was February 26th, Judge. Again, it took a little bit digging because it was resaved as a different thing, so I didn't know what it was in reference to. Once I located it, I located the adjoining report, which I'm going to have for counsel and for the court. And so it is not the same incident, but again, the premise of that argument, and frankly, the fact that it's audible from the outside at this point, we can agree that it is not inaudible. We can hear Ms. Clenney screaming.
And was that also taken from inside of your apartment building?
So that distinction doesn't matter, Judge, because if it can be heard outside, it doesn't matter if Ms. Clenney is expecting someone to be outside her apartment or not.
That's not my point. My point was that were they inside the apartment when that?
Yes.
So it could be heard outside the apartment?
Yes. So the defense's exhibit G is an audio recording from the outside of the apartment. It actually illustrates the state's point as to why Ms. Clenney would not have a reasonable expectation of privacy in audio sound waves that are beyond the reaches of her apartment. The detective can testify if necessary, but there were complaints from individuals 2 floors above and 2 floors below. So irrespective of the private floor, quote unquote, there were 3 months worth of Ms. Clenney screaming. And again, just as a reasonable matter, an individual does not have an expectation of privacy in their sound waves being too far and too loud for other people to hear. And again, it's audible that she is screaming in the videos.
Judge, just as a final matter, the way this building is laid out, and if necessary, I'm sure the detective can testify to this in all calls and ways. The only people that can access that apartment and the landing area outside of the elevator is with a key fob type thing that has to be inserted into the control panel of the elevator. That's it. That or an employee. So a reasonable person would know that nobody's coming to my foyer landing area outside the elevator. It's a disingenuous argument. It was a very private apartment complex.
I think that is true, generally speaking, and I think for the conversations that are recorded where she's not yelling at the top of her lungs. In fact, I had to turn it down when I was listening to the lowest point of my volume on my computer because she was yelling that loudly. I think the point is belied by the fact that these conversations had occurred previously in her apartment and had been disturbances that neighbors had called in. If they had not been able to hear her and if they had not been able to hear her from other apartment buildings, and they would have been called in, number one, and number two, the fact that it happened in February, so strong notice of the fact that everybody can hear her screaming. They've already called security on her, they've already called police on her,
Well, Judge, I think they called the police on them,
and
to be
that's
clear.
And that's true. And I'm not disputing the fact that there's an argument going on, but I think that also belies, at least with that video. I agree with you, the ones that she's not screaming, I think that she does have an expectation of privacy there, but she's talking in normal voice. But the one where she's screaming at the top of her lungs, for the purposes of this hearing only, I'm going to rule that I'm going to allow it in, because I don't think that there is that subjective expectation of privacy, number one, and number two, I don't think that it's one that society would reasonably accept for the purposes of this. And again, it's just for this hearing really addresses it later on. We're going to allow recording of the lobby, this is in a public space. The ones where she's not going to me, I've written down videos 1 and 2. The ones where she's not going and that she is in her bedroom, I'm going to exclude because I think that she does have an expectation of privacy.
So I have them listed, judges, items 1, 3, 5, and 7, items 1 is in the lobby.
So I think 3 is not yelling, 5 and 7 are yelling.
So with regards to that, Judge, she actually is elevating her voice.
Okay, they're the only ones, I mean, I made a distinction and that's what
That's
my
fine.
ruling is gonna be. I mean, when I have to turn my volume all the way down because the voices are that raised, I can see that there's a distinction potentially there. That's what I see in the second video, which is not the lobby, I did not hear the raised voices.
So then for the purposes of the record and the clerk, item in Exhibit 11, the court is admitting item 1 and 5, item 3 and 7 are not considered. The metadata of that obviously
Yes.
should be admitted just because of content. But so items 3 and 7 are not admitted.
I'm sorry, I thought she said 5 and 7.
I think the 7 was a continuation of 5.
Oh, okay, sure, okay, so,
I mean, if I'm,
okay, so it's just 3, I'm sorry, I misunderstood.
So next up for us, I think I have defense's motion to strike states. Motion to publish. Right, so, yes, Mr. Greco, you can go ahead and give your argument as to that, but your motion as well as statements.
Sure, Judge, our motion was very detailed. I think that we can rely upon that with much argument. I would just say, obviously, we've been scheduling this for quite some time, Judge. And at no time did the government file their motion for pretrial detention, right? It's just the plain language of the rule and the accompanying statutes indicates that this is close to first appearance, but then they latch onto the at any time before trial. But we've been putting the court and the state on notice of this hearing. And clearly it's an attempt to undercut the extremely high standard of Arthur, proof evident presumption rate. And we think that based on the delay in the state filing this, the delay in not only the arrest of Ms. Clenney, but the delay then in filing this is grounds for the court to strike.
Judge, I had a motion for pretrial detention ready when she was still in Hawaii. We decided not to because it would require us to put on evidence within 5 days, and it was done as a courtesy. The case law is clear. The defendant has not been granted any bail. We are in setting to set bail where it would be proper. It's almost first appearance, but for the fact that it's obviously not she's been in custody, but it's still a setting where a bail would be addressed. Notwithstanding that, the defendant's argument would lead subsection B of the pretrial detention rule superfluous. So it would basically make it so that that whole rule has no purpose if we're not filing it, at a later stage.
So I do agree with the state, when we are reading rule 3.32, the plain nature of the statute, that's if they can follow it at any time. I do believe that the case law that defense provided is distinguishable because there has been no onset in this, and it's not a motion to modify or vote on. It's a motion to no onset. Anyone who denied the defense's motion, let's go ahead then and get to the substance of the article hearing and the motion for publication. I'm assuming that you want to hear both together, but you guys can let me know if you have other ideas about that.
For judicial economy, I believe both are appropriate.
We're fine with that, Judge. Before we start, there's one objection we have, and it's to the state calling witnesses in this case. If you'll recall last week in our hearing on the 8th, the state asked if we had any witnesses to call. We talked about Ms. Clenney, the mother, and I said, Judge, vice versa, we would like to know if the state has any witnesses or exhibits so that we can prepare. We heard nothing from them. In fact, still, as of yesterday, when we filed our response, in the response, it actually says regarding the medical examiner, there's been no report or even a witness list advising he's going to testify. Yet this morning, we just were told a few minutes ago not this morning, like here at the hearing, right before you came in, they're calling the detective and the medical examiner. We have not had any opportunity to prepare. They did not advise us of this. We just want to make sure the court is aware of that.
Yes, Judge. So both two witnesses, our lead detective as well as the medical examiner, have been listed in discovery. We have a right to call any of these witnesses, any of the listed witnesses in our initial discovery witness list. The medical report, our medical examiner's report, was made available for copy inspection. That's not something we turn over. They have to request it through and then pay the fee to the medical examiner's office. So the fact that they have not done that, that they were advised of how to do that, that's on them. That's not us. And so we're calling those two witnesses. They know who they are. Just because they're not prepared based off of, for whatever reason that they're saying, we made them available this information ahead of time.
Judge, for whatever reason, is that they failed to advise us after Your Honor actually said, I believe at the hearing, you said, yes, everybody please exchange what witnesses you're calling. So I'm not saying that we weren't aware. Obviously, we're aware of these individuals. We have reports. That's really not the point here.
I think that as long as witnesses have been listed, then you're certainly on notice of those witnesses that can be called for the ARPA hearing, particularly in an ARPA hearing, depositions haven't happened, discovery hasn't happened, it's very close to the beginning of discovery also. We're dealing with a portion of this case that is at the very beginning, so I'm going to allow them to call their witnesses, as long as those witnesses have been listed, discovery, which they had. He's correct about the ending report, it's something that has to be requested independently. So let's go ahead and begin. And put your objections in.
Thank you, Judge. Judge, could we have some type of ruling from the court that in any future evidentiary hearings that the state will properly and timely disclose witnesses?
Well, I think that discovery only requires that they provide those witnesses as a witness list or any A witnesses that they believe might be used at trial. So I don't know that they have any discovery obligation.
I guess it's just more of following the court's order, which your order was.
And I think that my order would have been, and then maybe I misspoke, is that any witness lists have to be listed. As long as they have listed a witness list, and you have listed the witness list in your discovery obligation witness list, then I think that everybody's discovery obligations.
And Judge, because you mentioned it, I have to know the defense has not made any discovery within the list, but we are not raising that as an issue.
Okay. All right, so let's go ahead and get started.
Who do you think is very snippy and grouchy, beautiful Bernice? You talking about the prosecution?
John, is this okay? I mean, it's a little crowded over here, but.
All cell phones will be turned off. Step out. Step out.
It's me, Your Honor, I'm sorry. I'm sorry, I apologize.
Somebody's cell phone?
I'm sorry. I'm sorry to heard that. My bad. This is the court making an argument. Your Honor, today we're as the court does on pretrial detention and ARPA hearing.
Question mark. Does anybody know what that tattoo is on underneath her ear? Behind her ear? What is that? Does anybody know? I was trying to figure it out earlier.
Setting at this settings. As the court is well aware, there's certain different burdens of proof. It is a joint hearing. I'm outlining here on the screen right now the burden of proof and pretrial detention. Our burden is only to show the defendant is charged with a dangerous crime. Dangerous crimes include both homicide and manslaughter. I'm only noting manslaughter because the defense has raised a possible lesser quote unquote offense of manslaughter. So if they're conceding manslaughter, they're just conceding this ground. But the point is, homicide, which includes manslaughter, are both dangerous crimes. The state's burden is showing that there is a substantial probability that the defendant committed the offense. The factual circumstances of the crime indicate disregard for the safety of the community. obviously the homicide kind of illustrates that. There are no conditions of release pursuant to Florida Statute 907.041 that can ensure both the safety of the community and her presence in the future. This is analogous to the standards of Arthur, but the distinction between the two are twofold. One is the state's burden is greater. The state has to prove the defendant's guilt with evidence of the presumption greater. However, this is counterbalanced by the weight of the evidence and the likes of the evidence. Where in a pretrial detention setting, the evidence is not given as material to the state. In an argument setting, it is. So all evidence is used like material to the state. Conclusions, the inferences, they are all drawn like material to the state. And I'm not, just mentioning that, as an inference, that is a direct quote from Arthur. It is a preposition that is set in the foundation of Arthur. As to the admissibility of evidence in both settings, hearsay is admissible, affidavits are admissible, as the court correctly noted. This is a proceeding that occurs early on in the discovery process. Availability of witnesses, compilation of evidence, much of it is reviewed, but not necessarily processed or by an individual that can theoretically testify to that, which is an expert. And I mentioned examples where a medical examiner doesn't testify, the state just admits the medical examiner's report, for example. So the state has entered into evidence 32 exhibits that the court has had an opportunity to review. I'm not going to review all of them at this stage, and Detective Christino and Dr. Hudson will testify to much of the substance of evidence, but I do want to highlight to the court the date of incident. Much about this case, both from the state and the defense, will be similar fact evidence, but the date of incident is the crux of the situation. Mr. Obuselli was killed by a stab to the subclavian artery. He bled out as a result of that stab. Incidents from before can certainly cloud or create a perception of what led to it. And the dynamics of that certainly are at play, as the state is outlining in its motion. We're not avoiding that at all. But the date of incident, the circumstances under which the defendant killed Mr. Obuselli are particularly important. We extracted Mr. Obuselli's phone, and the day became, just woke up home.
What in the world? Oh.
That was at 10 a.m. Christians in their living room, you can see it in the background, and he was singing.
Okay, it's kind of hard to hear, so I want to say what he's saying. This was at 10 a.m., this video they're showing, the same day that he was unalived.
Lip syncing. The defendant is dancing with their dogs. Christian just recording.
Hey, yo, maybe dancing like Austin. Just get the fuck away. Yeah. Hey. Yeah.
The state will note in this video, the court can see the defendant's legs, and for example, the bruising that was photographed several days later and the defense will introduce on its own already exists. Christian is very clearly alive. So those bruises could not have been created in the quote-unquote struggle as the defense characterizes it, where he was at. Just black, they existed before. And the court, through the other evidence, can compare the bruising, including the photographs that the state submitted to it of the defendant on the data. But what matters is the incident. Christian leaves the apartment at 3:55. This is the state's exhibit at the bottom, 14, channel 9. 3:55. He's on the phone And by that I mean you'll see in the surveillance video, the court can see him holding his phone out on the phone. He's walking his dog. The defendant called Christian repeatedly, almost at a frantic call. For the record, the times are 1955, but that's in universal coordinated time, so this is local time 355. She called him 3 times in quick succession. Twice he did not answer, and then once was for a 40-second call. 10 minutes later, the defendant gets on Instagram Live. And on Instagram Live, she has marks on her shoulders. She has bruises. And again, we have not avoided the fact that this was a mutually abusive relationship. The issue is whether the defendant's conduct in stabbing and killing Christian is justified. So the bruising the defense is going to try to suggest was as a result of a struggle. Simply do not exist. So Mr. Ombuseli returns at 4:32 and 44 seconds. He enters the apartment or exits their walkway, 22nd floor, at 4:33, which is at the exact same time the defendant is called. It's a 13-second call. And then 10 minutes later, the defendant calls her mother. I redacted her phone number. Those were 2 calls at 4:43 and 4:49. And we know that the incident occurred in the first call because Mrs. Clenney admits it.
I want to show you guys something really quick. This is something the defense put together, or I'm sorry, the prosecution put together. At 4:01 p.m., Clenney called Christian. Then she goes on her live Instagram, which we watched that live Instagram in our video called Messy. If you haven't seen it, the thumbnail says Messy. 4:33, after she gets off that Instagram video, she called him again shortly after posting the video. 4:33, Christian walks into the apartment. 4:43, Clenney called her mom. That call lasted until 4:49 p.m., just over 6 minutes. 4:49 p.m., Clenney made a second call to her mother. They spoke until about 4:56 p.m., a little over 7 minutes. And then at 4:57 p.m., Clenney calls 911. The police officers exit the elevator at the unit at 5:04 p.m. I want to make a note here that at the 4:49 mark is where I believe everything happened. So she calls her mom because she says she's scared. And her mom was on the phone, I think, while everything was going down. I'm not positive, but unless they were arguing at 4:43 when she was on the phone with her mom, they got off the phone, she stabbed him, and then before calling the police, she calls her mom because she says she doesn't know what to do. Anyway, I just wanted to show you that timeline that the prosecution has put together. It does make it pretty simple for us all to follow.
So fewer than 10 minutes after Christian walks into the apartment, it goes from a simple walk, relatively calm, to him being stabbed. And the state notes that in Mrs. Clenney's statement, Mrs. Clenney, excuse me, all Mrs. Clenney suggests is that she heard the defendant yelling that Christian was lying and for him to get out. And the state notes he's entitled to be there as a resident of that apartment. The defendant has no right to kick him out. But the simple fact is the defendant is making affirmative accusations. The defendant is making the attacks on Christian. The defendant waited 10 minutes to call, or excuse me, 10 minutes later, the defendant called the building security. It's an 18-second call. And then 4 minutes after that, she called him. Looks like the medical portion of the medical call.
You need to stop doing on the line and sticking your hand. You're not hitting on. What, ma'am? Ma'am, what is the address? Ma'am, there's a hospital nurse. I can serve for my society too. Is this a hospital or a business? Ma'am, can you hear me?
The defendant acknowledges her actions. She apologized. Please arrive within 5 minutes. I'm not going to air here the state exhibit 21 still shot. It shows the defendant cradling Mr. Gonzalez's body. The defendant is transported to Miami Police headquarters and interviewed, and she gives herself an statement. It's inconsistent throughout. It conflates the dates as a whole. It suggests that Christian had gone to Subway and that this incident occurred as a result of the Subway. We know from the key fob records, we know from the video, he was not returning from Subway. This argument happened earlier today. And it very might well has happened, as the defendant suggested, but she's conflating both of them to justify a self-defense claim.
What happened? Oh, they had an issue.
She said, because I know I was afraid. Just for the record. That's it. What's very important is actually the arch of this statement. Is when Ms. Clenney discussing how she got up after they were arguing over the phone, went to the kitchen and grabbed the knife. She paused. She stopped. She sat in her thought. The detective interrupted and asked her some questions, but she had to get out. She did not know whether this was justified at all. Based on the totality of the evidence, based on the medical examiner's testimony, the court will see that it was not justified at all. The defendant's statement is not credible. She could not have thrown a knife that would have landed at an ankle, punctured 3 inches deep, and not lacerated, for example, Mr. Gonzalez. That was physically impossible. Had she thrown the knife and it entered at a downward angle, she would have had to be above it, which of course she was not. No, the defendant stabbed Mr. Gonzalez. It punctured his body 3 1/4 inches, and it pierced through the subclavian artery. The court has those medical examiner evidence and reviewed it, and you can see the guy at a downward to his right, the person looking at him left angle. She stabbed him cross body. And the state agrees with this claim. This was not justified. And for those reasons, the state will ask the court hold.
I'll defer to that, so I'll have
State law detectives,
Okay, so now they're bringing in the lead detective on the case. So this should be interesting.
Do you solemnly swear or affirm the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
I do.
Good afternoon, detective. Can you please introduce yourself to the board?
Detective Yermain Brasino.
Detective, what do you do?
I'm assigned to the homicide unit.
How long have you done that?
A little over a year.
Before that, do you have any law enforcement experience?
Yes.
Can you please tell the court your law enforcement experience?
I've been an officer in the city of Miami for about 9 years, 4 of which I was a detective in the robbery unit, and 1 now currently in homicide.
Do you know a person by the name of Courtney Clenney?
Yes.
Do you see Ms. Clenney in the courtroom today? Okay. Let's talk about how you came to know Ms. Clenney. And specifically, I want to focus you on April 3rd, 2022. Is that the date that you met Ms. Clenney?
Yes.
Did you know her from beforehand?
No.
Having discussed the April 3rd, 2022 day, let's walk through it. Under what context did you first meet Ms. Clenney?
It was at her apartment, just outside. She was detained at the moment.
Okay. And let's kind of walk through that. Why did you end up responding to her apartment that day?
I was notified that there was a stabbing and the victim had been taken to rider trauma and succumbed to his injuries.
So at the time that you met her, you already knew Mr. Mbaselli was passed?
Yes.
So let's pierce this up. First, you met her at her apartment. Where's her apartment?
Her apartment is at 3131 Northeast 7th Avenue.
Is that Miami-Dade County?
Yes.
So you mentioned you were notified because he had succumbed to his injury. Obviously, that you're a homicide detective. That's how you got involved.
Yes.
And why is it that you're the lead detective?
It was just my turn to take the next case.
So just as a premise, you didn't ask for the case. It was just
correct.
Okay. So you responded to the scene of the homicide. You met Ms. Clenney. What did you do?
Say that again.
What did you do?
We responded to the scene. We began to check the apartment and get in contact with the crime scene. And simultaneously, we had Ms. Clenney transported to the station.
Before we get into what happened at the station with Ms. Clenney, let's discuss the events of the day. Do you know approximately what time police was called out to the apartment?
I don't recall.
Okay. Would anything refresh your recollection?
No, not right now.
Okay. So you're aware that at some point police got called out to the apartment?
Yes.
You've reviewed the evidence, the body cameras, all the evidence in this case?
Correct.
Okay. So what happened when police officers arrived to the scene?
When police officers arrived, they were able to make contact inside the apartment. They saw Ms. Clenney cradling the victim. They were able to separate the two of them, provide aid to the victim while they waited for fire rescue to show up on scene.
And then what happened after fire rescue showed up on scene?
They were able to transport him to Jackson.
And do you remember approximately when Mr. Mbaselli was pronounced deceased?
I would have to go back to my notes.
You can refer to the report. Let me know when your memories are fresh.
At 5:55 p.m.
So 5:55 p.m., he's pronounced deceased. You are dispatched as a homicide detective. We already mentioned how you responded to the scene, initial check of the crime scene, contacted the crime scene, and sent the defendant over to the police department. So far as everything, I guess, per protocol?
Yes.
Okay. When the defendant arrives to the police department, at some point do you end up interviewing him?
Yes.
Okay. Now, just for context, did you read her Miranda rights?
I did.
Did she waive her Miranda rights?
Yes.
Was that audio and video lead recorded?
Yes.
Okay. And I'm directing the court to the recorded statement. So I'm not going to belabor the point. The court has reviewed the recorded statement, but would you synopsize the defendant's statement for the court?
So she told me that she was at the apartment. The victim had went down to go to Subways. When he went to Subways, they began to message each other, and through text messages, they got into an argument over sharing each other's location. He then decides to come back to the apartment. Shortly after he comes back to the apartment, another argument ensues. At that point, the defendant says that the victim grabbed her by the neck, slammed her against the wall. She was able to break free. Then she was gonna call her mother, and he didn't want that to happen, so he grabbed her and put her onto the ground. She wasn't able to explain how exactly that happened. After that, she was able to break free once again, at which point she goes to the kitchen. She grabs on a knife, and then she states that the victim ran towards her, and that's when she flung the knife or threw it, and it hit him in the shoulder.
What did anything besides that? Did Ms. Clenney say anything besides that in addition of substance, I guess, regarding this incident?
No.
So regarding the injuries,
Yes.
in this circumstance,
Yes.
I want you to tell the court, I guess, how you're evaluating the case. Where are you in your analysis of the facts thus far?
At that point, we were looking at it as a self-defense at first, but then later on, things started revealing that it wasn't what we thought.
So let's talk about that. So at the point in which you finish interviewing her, despite some of the inconsistencies in the statement, you are evaluating the case for a possible self-defense claim.
Correct.
Is that one of the reasons why you document how she looks in her injuries?
Yes.
Okay, so let's parse through that. Did you have crime scene take photographs of her?
Yes.
I'll direct the court just as general reference to the crime scene photos. Were there bruisings on her?
Yes.
Okay, will you tell the court where there was bruising?
She had some bruising over on her legs. She had some small bruising to her arms, and that was about it.
Okay. Do you have experience in seeing fresh bruises versus old bruises?
Yes.
Okay. Have you, in this context, right? Just as a human, have you seen bruises?
Objection, Judge, lack of discipline, lack of predicate for this future opinions. Judge, I believe that the state intends to try to elicit some kind of expert testimony from the detective regarding bruising. That's clearly the purview of an expert. And this, as far as we know, this detective has no medical training. He's not a doctor. He's a detective. So I object to him making any opinions as to when bruises were formed.
So there's a lot of parsing to that, and he's not issuing an opinion as to when a bruise was formed. He's issuing an opinion as to whether it's a new bruise or an old bruise. As human beings, we know what bruises look like in an older bruise versus a newer bruise. Older bruise is darker versus a newer bruise, which is lighter and coming into
I'll
color.
object to the counsel testifying as well, Judge. He's not an expert either.
I'm going to go ahead and, I'm not going to allow that particular line of answers, but.
Judge, can we approach sidebar very briefly?
I agree with the defense about that part, though. It's not their. It shouldn't be their decision. I mean, he can't testify on bruises. I couldn't testify on bruises. You do need a medical thing. But if the defense is trying to, or the prosecution is trying to argue, well, they're basically stating this is why they moved forward with the case against her, or this is what they believe happened. If she didn't have any marks on her body, then we would know that obviously she's not telling the truth. What do y'all think? Are y'all still there? Are you still in the comments? Have I lost everyone? Patty, you don't like the defense attorney. See, I just think he has a tough job. I could change my mind about him. You know that happens a lot. A detective can notice bruising. Okay, you go, JPC. Hey, JPC, Grandmama. That's true. A detective could notice something like that that could contradict her statements.
The evidence was accepted by the court, and if it hasn't, I'm just moving all of the state's exhibits into evidence.
No, other than the was previously noted in the
And I'll just refer to them as their sub-exhibits, and I believe in evidence there's State's Exhibit 1 or 1A. Continuing, did you see bruising?
Yes.
Okay. And that bruising you mentioned it was on the arms and the legs.
Yes.
Did you see any bruising on her neck?
No.
Did you see any hand marks on her neck?
No.
Did you see any bruising coming in from her neck?
No.
Did you see any bruising consistent with her having been grabbed by the neck?
No.
Did you document the area of her neck?
Yes.
And are those in, I guess, the photographs that were documented by forensic?
Correct.
You had an opportunity to review Mr. Umbuseli's cell phone extraction.
Yes.
As part of that extraction, did you see videos from the same day but earlier before the murder?
Yes.
Okay. In those videos, did you see bruises on Miss Clenney?
Yes.
You also had an opportunity to review the Instagram Live video that she posted between Mr. Umbuseli leaving the apartment and returning.
Yes.
Did you had that opportunity to review that video?
Yes.
And in that video, did you see the bruising on her?
Yes.
Now let's speak specifically. Let's speak specifically about those bruises, right? Let's separate arms versus legs. The bruising on her arms, were you able to see them in the Instagram Live video?
Yes.
And again, that video was posted before this murder occurred.
Correct.
So those bruises were before the murder occurred.
Yes.
Let's talk about the legs. You saw bruising on her legs in the earlier posted video of her dance.
Yes.
In that video, are those the same bruises you saw later that day?
Yes.
So, and the metadata of those videos were like 10, 11 in the morning, same day.
Yes.
So let's continue through this. You mentioned that Miss Clenney told you and showed you how she threw the knife or flung, as you said, at Mr. Umbuseli.
Yes.
Would you please recreate or reenact to the court the manner in which she claimed she threw this knife?
She said she put it over her shoulder and then she just flung it forward.
And I'm just noting, if you got to talk about the record, right? So you're saying that she got her arm back and threw it forward.
Yes.
And I guess just as a parallel, it's kind of like a football.
Yes. Correct.
It was not a fling using like a flick of the wrist.
Correct.
Okay. So after you interviewed, okay. Actually, before I move on from that, did she tell you the distance in which she flung the knife?
Yes.
Okay. What was the distance that she told you?
She said it was about 10 feet apart.
Did she point to the room?
Yes.
Okay. What was it that she said when she pointed to the room?
She said the distance was bigger than the room that we were in.
Okay. And so in that context, as if the room was 10 feet, it was longer than 10 feet.
Yes.
So she was at a distance of approximately 10 feet when she claimed she had flung this knife.
Yes.
And did at any point she say whether Mr. Umbuseli was armed?
No.
No.
He wasn't armed.
Okay, so she did say, but he was not armed.
Correct.
So she acknowledges Mr. Maselli was not armed in excess of 10 feet from her when she threw this knife at him.
Correct.
So progressing from that, during the interview of the defendant, you became aware that she was on the phone with her mother during the incident.
Yes.
What did you do as a result of that?
As a result of finding out that she was on the phone.
Yeah, after knowing that she was on the phone with her mom,
Uh-huh.
and then you finished the interview, what did you do?
I was able to get in contact with the mother over the phone.
Okay. Did you do an audio recorded interview of Miss Clenney's mother?
Yes.
Okay. Were you aware that there was anyone present besides you and your fellow detective on that call?
No.
I so hope that we get to hear the phone call between them and her mother right after this incident. Wouldn't that be good? I bet we have to wait till trial, but I so hope we get to do it.
Okay. At what point did you become aware that there was someone else on that call?
When the attorney arrived at the station, her father jumped spoke from on the same call, saying that the attorney was there and that they would like for the attorney to be present for any more questioning.
So during the length of your interview with her, you were not aware that she was with someone else in her person.
Correct.
As you were doing that interview, what did you ask Mrs. And I directed the court to the audio recorded statement that's in evidence, but again, will you please synopsize the contents of that call?
We spoke about the relationship between the victim and the defendant. And she explained to me that I believe it was about a week before the incident that the mother was there for 6 days because Christian wouldn't leave the house and he kept following her around. So she came down to Miami to see if the transition of him leaving the apartment would be a lot better than just them two trying to figure it out.
Okay, I apologize, guys. I'm having a little bit of technical difficulty. Just give me just one moment. Okay, I apologize, guys. I'm having a little bit of technical difficulty. Just give me just one moment. Ooh, feedback. Oh, maybe it wasn't mine because it goes to live. But now I can't get it to open up and stay open. There it goes. Okay, it's fixing to come back on. I have a very quirky little mouse that pops up when I don't want him to pop up. And he starts doing things that I don't want him to do. I'm not kidding. It's like my computer is possessed with this additional mouse. I've tried to turn it off and everything. I'm not a technical person at all. Y'all know this
Get
about
away
me.
from her and that he was lying.
Correct.
Nothing more than that.
Correct.
Mrs. Clinton didn't say anything about owl that hurts or any indication that the defendant was injured in any way.
Correct.
Did Mrs. Clinton tell you the circumstances of the incident, how she knows the incident occurred or under what circumstances?
On the day of?
Yeah.
No.
Okay. At any point, did she tell you she knows what happened?
No.
So having moved on from that, earlier we talked about how you were evaluating the case for a possible self-defense.
Yes.
So what did you do as a result of, on the date of the incident, what did you do as a result of where you were at?
I don't understand.
In a nutshell, after you interviewed the defendant, you interviewed the victim,
Yes.
or rather you interviewed the defendant, you interviewed the defendant's mother, crime scene, photographed the scene.
Yes.
They documented her, you collected all pieces of evidence. What else happened that night?
Nothing else. We finished with the scene, and the defendant was let go.
Okay.
Was
Is
released.
that normal protocol?
Yes.
Okay. Why is that normal protocol?
At the time, we didn't have enough to say what actually did occur, and we still needed to continue the investigation.
Had a decision been made as to the defendant's criminal culpability at that point?
Well, at first, I was leaning more towards a self-defense.
No, we discussed that. My
Okay,
question was,
yes.
did you close the case and say it was self-defense, or was it still open?
No, it was still open.
Okay.
Yes.
So the investigation was still open, it was still pending. Okay, so what are the next steps you took in your open investigation?
Oh, okay. Well, we did several warrants for everybody's cell phones, the victim and the defendant's cell phone. We did warrants for social media. And yeah, I believe a couple of other warrants as well.
As a result of some of these warrants, did you end up briefing the state attorney's office about the investigation?
Yes.
Okay. As pursuant to that briefing, were there subpoenas that were sought?
Yes.
I'm just going to go through things that are in evidence, but did you obtain police reports and body camera from Las Vegas?
Yes.
We're going to talk about this. I'm just going through everything. We mentioned warrants. You said on the phone. Which phones are you speaking about?
I'm speaking about the victim's cell phone and the defendant's cell phone.
Okay. Were you able to get the extraction from the victim's cell phone?
Yes.
Were you able to get the extraction from the defendant's cell phone?
Not yet.
Is that still pending and being attempted?
Yes.
From the extraction, were you able to obtain data and information?
Correct.
Okay, so we'll cross that bridge in a little bit. Pursuant to subpoenas, were you able to obtain surveillance footage and incident reports from one party, so condominium?
Yes.
Did you also obtain lease documents?
Yes.
As part of those documents, were you able to obtain the FOB records?
Yes.
You mentioned warrants on social media. Was that the Instagram warrant?
Yes.
And is that how we know the precise time in which Ms. Clenney was live?
Yes.
Did at some point you obtain the call detail records of Ms. Clenney?
Yes.
Or the defendant, sorry. Even though I lost myself on that. At some point, did you obtain the criminal history of the defendant?
Yes.
At some point, did you obtain, pursuant to subpoenas, as we were discussing, financial records belonging to the defendant?
Yes.
Now let's go back again. Date of incident, crime scene process. At any point, did you obtain a diagram of the apartment?
Yes.
Was that diagram to scale and measured and documented?
Yes.
Just noting for the court, Exhibit 19. Will you please describe to the court the crime scene? again, the court has the photos, but just outline it for it.
Okay. The crime scene is an apartment located on the 22nd floor of the One Paraíso building. It's a 3-bedroom apartment with a single kitchen and living room. You want me to explain also where the scene was located, or?
Yes, please, if you don't mind. So
Okay.
let's parse that through, and actually let's take steps in this. When crime scene enters an apartment,
Yes.
we tell the court the various photographs that they take, such as the
Yes.
initial scene, the measurements, and so on.
So before anything is done, we take all photographs from the first floor of the building to show what building we're going to. The elevator, the floor of the elevator that it stops on, the number that's fixed to the front of the apartment.
I don't want to take away from what he's saying, but I wanted to show you guys something really quick. So she had a 3-bedroom. This was the 3-bedroom layout. I kept trying to figure this out because I was trying to figure out the layout of that unit when they kept going in with the body cam. Can you guys see it okay? So you got a bedroom up here, a bedroom over here, and a bedroom over here. This is the foyer area off that we kept seeing off of the elevator, right? So there's your elevator. You go into the door, which is where they were. And around here, around this area right here, was where they had Christian. See, I was thinking the kitchen was way over here, but I guess not. So it was around this area right here. There was a lot of other space around this house. It just, to me, looks so small. Didn't it look small to you guys from what we saw? I wanted to see something else too. Hang on. Look back on the images of it. I was hoping they'd have pictures. This is a tall building. It has 53 floors, so she only lived on the 22nd. So she was in the middle of the building. She wasn't. Did y'all get the impression that she was on the penthouse? Because everything, like in some of the stuff they keep showing on the media, I kept thinking that they were in the penthouse. It did look very open, but it's like that part looked open, but I guess it just, what was it? How many square feet? Did we say about 1,300, I think? No, that's way too much, 1,300. They had 24-hour security, valet, and concierge. Beach club with lounge area for private events. Private pool, marina, and restaurant. Adult tanning pool. What does that mean? Adult? Well, I guess no kids are allowed. Pool deck with pool cabanas and barbecue area. They have a theater. Okay. I'm sorry, I had to look at that. So does it say over here how many square feet? Here it is. Oh, wow. That is a lot of square feet. So just the unit itself, AC and portion is 1,873 square feet. But did you guys not get the impression that when you were watching it in all those videos of the body cam footage, it just seemed so freaking small? I did. You would say that child-free adult insinuates something else. Because it's in Miami, I bet it's where they allow women to wear thongs. What you want to bet? That's what that pool's about. Because there's no way they allow nudity. There's just no way. I know it's as big as I know. It's bigger than my house was. Anyway, I will get back to this. I'm going to go back just a little bit because it was interesting what he was saying.
Crime scene is an apartment located on the 22nd floor, the One Paraíso building. It's a 3-bedroom apartment with a single kitchen and living room. You want me to explain also where the scene was located, or?
Yes, please, if you don't mind. So
Okay.
let's parse that through. And actually, let's take steps in this. When crime scene enters an apartment,
Yes.
you tell the court the various photographs that they take, such as the
Yes.
initial scene, the measurements, and so on.
So before anything is done, we take all photographs from the first floor of the building to show what building we're going to. The elevator, the floor of the elevator that it stops on, the number that's fixed to the front of the apartment, the front door, and then all wide-angled and far away photos of every room in the apartment. And then initially they started taking photos, closer shots of any blood or weapons or anything that has to do with the incident.
Will you please describe to the court I'm going to separate them into 3.
Yeah.
There's the 3 different blood scenes.
Yeah.
Will you please explain to the court what that means?
So the first one that we find is where we initially found the victim, which is the first puddle of blood. The second one was more towards the living room. And then the third one was, it was more between blood spatter and droplets that were moved around not moved around, but showed that the victim was walked around the apartment.
Objection, Your Honor.
Okay, this is the part I don't understand. He was walking around while he had how long do you think, if we look back at this, I want to see something. If we look back at this timeline, she calls 911. Oh, shoot. Oh, what happened? Where'd it go? Hang on. I'm on the wrong thing. She calls 911 at 4:57. We think that he was injured at around what? Around the 4:59 mark? So it's like 7 minutes. I saw a lot of the dog paws in some of the crime scene things where they were able to transfer a lot of fluids and stuff throughout the house. I'm trying to be careful what I say, you guys. I just pictured that she did it. He fell to the floor and he was, he was laying there just for the longest time. But it sounds to me like what they're saying is, no, he was the reason that there was so much blood on scene, because there was a lot throughout the apartment. And I wanted to find out more about how that all got transferred. So I guess it makes sense. I just wonder how long he was able to do that.
So let's piece through that. So there were 2 pools of blood, which is 1 and 2 that we just discussed, and then the third where there was droplets and spatter.
Yes.
You described this one. I'm just noting it for the record. The first one, the first pool of blood is where the defendant was located,
Yes.
holding the victim. The second one you said was further back, and it was just a pool of blood.
Yes.
Did you see blood transfer on the wall?
Yes.
Okay. What does that blood transfer mean?
Well, it can mean numerous things.
Okay, but I mean.
But the one on the wall was, it means that it's blood spatter, meaning,
No, I'm talking about the transfer. So
Okay.
the second pool of blood, if you recall, there
Okay.
was, again, I'm just noting the exhibit that's in evidence. There was blood on the wall,
yes, I remember.
and it was kind of filled. It wasn't spatter or drop. Do you recall that?
Not so much.
That's fine, then we'll move on if you don't know. So let's talk about the blood spatter and the droplets. You
Objection,
mentioned,
there's lack of predicate.
I do understand your objection to the category.
Did they object? I think too, some of it got on the dog's hair, and the dog hair might have walked next to the wall and rubbed it on the wall too. I would think. Did she just realize the cameras were on her and she's starting to? No. I don't think she's been playing a whole lot for the cameras in this trial. You know how we sometimes say that you could tell they are when they are? I don't think that's the case here. One thing I'll say about her is I notice when she starts to cry, she kind of turns away from the camera. What is that on her neck, y'all? It looks like a date of birth. She said something about putting her grandmother's date or something on the back of her neck at one point. 11 minutes before the 911 call? That can't be right, though, based upon the timeline. Oh, y'all know we're going to have to dive into that timeline. You know, I just can't let that be. we gotta know.
We were last left off on the spatter and droplets. Do you know what spatter is? Like, just can you describe that?
Yes, spatter is more of a way that the blood kind of like just, if you stab somebody or you
I'm not asking for
Objection.
the
if
point.
you swing any type of liquid, it makes a certain movement that it shows that the blood was traveling at a certain direction.
So how is it different from a droplet?
A droplet is it's
Objection.
I'm not asking for conclusions. Judge.
I have this, let's just
Sure.
stick with what is solved in the department and principal directs to at least solve this.
Okay. Did you see droplets throughout the house?
yes.
What does that mean?
Means that there was blood following straight down at a straight angle.
Objection, Your Honor.
Okay. And where did you see these droplets?
In the living room heading towards the bedroom, the master bedroom.
Just going back about the flinging of the knife. Do you have any information that the defendant knows how to throw a knife or is some kind of expert in throwing a knife?
No,
At any point in time, did Mr. Busella go to the medical examiner's office?
yes,
Was an autopsy performed on him?
yes,
Have you reviewed the contents of that autopsy?
yes.
Let's discuss that autopsy. Who was the medical examiner that performed it?
Dr. Hutchins.
As a result of that autopsy, did he determine a manner of death?
Yes,
What was that manner of death?
by stabbing.
Okay. Did he rule the death any particular manner?
No. Oh, I mean, yes, homicide.
Okay. At any point in time, did you become aware that it was impossible to have thrown the knife? Or at least that was the opinion?
Objection.
I'm just asking.
Can you repeat the question?
At any point in time, did you become aware that the throwing of a knife could not have caused that injury?
Yes.
Approximately when? Like, where were you in your investigation?
I was later on in the investigation.
So let's talk about some of the other evidence that you obtained. So we discussed Las Vegas. Did you get a chance to receive those reports and review them?
Yes.
Just directing the court to the Las Vegas reports. At any point in time, did you review the body camera?
Yes.
Not to belabor the point, but will you please synopsize to the court what was in those reports and in the body camera?
In the reports, it explained that the victim and the defendants were staying in a hotel room in Las Vegas. They got into an argument. Through that argument, the defendant threw a bottle of water at the victim while he was laying on the couch. And security was called to the apartment due to the argument.
It was a glass bottle of water.
Did you review the defendant's statement?
Yes.
To Las Vegas?
Yes.
In that statement, what did she say?
She says that she likes to throw things and that she guesses that she was the one that threw the bottle at him.
Did she acknowledge throwing items at Mr. Umbaselli before?
Yes.
What were those items?
Plates and other items.
Was Mr. Umbaselli interviewed?
Yes.
As part of that interview, did there come a time where the officer asked Mr. Umbaselli a bunch of questions as to whether the defendant was violent with him prior to that?
I can't remember that right now.
Sure. I'll just direct the court to the video. Following the defendant's admission, was she arrested on that case?
Yes.
Let's talk about the cell phone extraction. Did you get a chance to review Mr. Umbaselli's cell phone extraction?
Yes.
Will you please tell the court, what a cell phone extraction is?
It's pretty much just an extraction of all the data, messages, photos, videos, and even sometimes social media saved posts can be extracted from the phone.
When you received the extraction from his phone, did you get an opportunity to review the photographs?
Yes.
Did you get an opportunity to review the videos?
Yes.
Did you get an opportunity to review the text messages between the defendant and Mr. Umbaselli?
Yes.
I want to discuss with you regarding your review of those, and I'm going to bear with me because I'm just going to be very specific in directing you. You have all the records, just so we're clear.
Yes.
When they're produced, do they produce in a PDF? How do they come out?
They're produced in a PDF.
Do you recall how many text messages there were?
It was over 12,000. I believe it was 12,220. Something like that. Yes.
Do you remember from when to when those messages were?
Yes. Those messages go back as far as 2020.
Okay. You remember when? November, December, January?
I can't remember the month.
So from 2020 to April 3rd,
Yes.
The complete messages into 12,000 or so.
Yes.
Let's discuss the messages from, just gonna be very delicate. October 9th through the 11th, which is in the evidence of Exhibit 4. Did you get a chance to review those?
Yes.
Will you tell the court, again, just a synopsis because the court has them, what is covered in the messages in State's Exhibit 4?
Might never review my notes really quick.
Yeah, if you need to refer to anything to refresh your recollection, go ahead and then let me know when you're ready.
Patty, according to,
All right.
oh, never mind.
What was discussed on the October 9th through the 11th messages?
So, based off of the messages, there was an argument that occurred again. Mr. Christian writes to the defendant that she stabbed him, and he wants to get into the room, that he needs help, and she pretty much just told him go get first aid, and pretty much just brushed him off.
Later on in those messages, does he confront her about hitting him with a phone?
Yes.
Okay. Does he confront her about her spitting on him?
Yes.
Was it in the context of all of these messages where he also confronts her about stabbing?
Yes.
Did the defendant respond to these accusations from Ms. Romaselli?
Yes.
What did she say in response?
You
can review your notes, yeah.
Yeah, she pretty much just tells him to go get first aid. And then for several hours, she just didn't answer anymore till the next day.
At any point, does she apologize for her action?
Yes, the following day.
And does she do it in the context of acknowledging the accusations?
Yes.
In those messages, were there any affirmative allegations by her to Ms. Romaselli?
Yeah, she pretty much told him that she apologizes, that she shouldn't have treated him that way. She shouldn't.
Let me cut you off. You
Okay.
didn't understand my question. My question was, did she make accusations about Mr. Romaselli? So, for example, he sent her a message about you stabbed me.
Yes.
Did she reply saying, well, that was because you were choking me?
I can't remember right now.
Did she make any accusations towards him at all in those messages?
She did, but I can't remember the specific accusations.
Other records, that evidence. Let's talk about January 30th to February 1st. Did you review messages from that incident?
Yes.
Okay, will you tell the court what that incident is about?
Um,
That's Exhibit 5 for the record.
On those messages, the defendant was trying to reach out to the victim, and he pretty much just said, yes, Courtney. At that point, she didn't like the way that he wrote to her, and just started becoming very angry and asking him about why he said, yes, Courtney.
Were there audio messages associated with that?
Yes.
At any point in time, did he communicate to her that he had made a mistake because he was doing something?
Yes.
Okay, what was it that he communicated to her?
He explained to her that he was just trying to answer quick because he was watching the overtime on a football game.
Okay. Do you know what overtime he's speaking about?
I believe it was the Bengals versus the Chiefs.
Okay. And so you're referring to the overtime of that?
Yes.
So at any point in time, was there, I guess, did the messages continue, or was there a break in time between those messages?
There was a break.
Okay. At the end of the, I guess, argument over the tone of the messages and the next message, what is the next message that occurs in that break in time?
May I go back?
Sure. What was the first conversation after?
So the first one that I recall, it was the defendant telling him, "I hope this gives you time to think about what you've done." And then she tells him, "Enjoy the hospital." And then after a little while, he messages her, "I lost a lot of blood. Can you come? I need you. And then she asks him, are you having fun? And this is all between him writing her that he's losing a lot of blood and at the hospital.
Were you able to find out what happened in that time period?
Yes, she ended up cutting him with a knife.
Okay. Now, how did you figure that out?
It was all in the messages that he wrote, and she responded back to him.
Were there also photographs from that date and time?
Yes.
And how is it that you figure out the date and time that a photograph is taken from the device?
So through the properties of the photo, it will show you when the photo was created, and it was at the same time and date as these messages were sent to him.
And just so we're clear, the messages had, or the photographs also had location information?
Yes.
Do you remember where the location of that was?
It was on the east side of the 195.
Okay. Was that, is there a street that's there?
Yes, that's called the Julia Tuttle, but it leads up to the hospital. It was just it was pinpointing right at the hospital, Mount Sinai.
Okay. The state's directing the court to Exhibit 6. So in those photographs, you said it shows that his lip was sliced.
Yes.
And that the location of those photographs were at a hospital.
Correct.
Were you able to locate images of those injuries?
Yes.
Okay. Directing the court to Exhibit 7. Will you just describe the court to what those injuries were?
It was a large laceration that goes from the lip to the bottom of the chin.
Okay. And what is a laceration?
Say that again.
What is a laceration?
Laceration is it's a cut.
So there was a large cut from
Yes.
the chin to the lip, and there were stitches, you said.
Correct.
Did he appear to have any other injuries in that stitches photo?
Yeah, he had another small laceration here to the left, I believe the left of the face,
And for the record, you're pointing
to the
like at the cheek.
closer to the chin, to the cheek.
Okay.
As well as we noticed that on the photo with the stitches, he had 2 black eyes, or what you would call raccoon eyes.
Okay. So there was dark discoloration on his,
Yes.
on his face by his eyes.
Correct.
And then at any point in time close to these incidents, was there another selfie of the defendant for comparison?
Yes.
Or not defendant, excuse me, the victim. State's Exhibit 8 for the record. Were there more incidents documented in text messages?
Yes.
Okay, let's discuss February 27th and 28th.
Okay.
What was documented in the text messages there directing the court's Exhibit 9?
Let me go back really quick.
Sure, you can look at your notes. All right, sir. What was discussed in the February 27th and 28th text message?
So during that time, the victim, he wrote a very large message to the defendant. He pretty much started explaining is love gonna kill him. Through that message, he explained how the defendant has stabbed him several times, hit him with a phone, with other items, calls him the N-word on several occasions. And in regards to hurt him, he says that he has tried his best to work through it and that after he goes through, after he starts his seeing a counselor, a psychiatrist, that he's gonna leave her. But then he also went into explaining that if she was still willing to work through it, that he would still want to work through it.
Following this, did the victim begin documenting audio and video recording incidents between him and the defendant?
Yes.
Were there any of these documented incidents before this text message? This lengthy text message? By that I mean secret recordings, right? He started secretly recording her.
Yes.
Prior to this text message, did he secretly record her?
Yes.
Okay. He did?
Yeah.
Okay, when did he secretly record her before this?
I can't remember the dates.
Okay. After this date, for certain, he did.
Actually, let me review real quick.
Sure, go ahead. If you need to review your notes to refresh your thoughts.
I wanted to, while he's on a pause, I want to show you guys something now. I want to give you a warning. This is gross. So if you don't like blood and you don't like to see somebody cuts or anything, then you might want to just step away for just a few seconds. I'm going to put up a picture of Christian that was taken at the hospital in his face so you guys can see what happened. So, ready? Walk away now if you don't want to see it. So this is the first, one of my questions was, is that blood around his lips? And the one that's further to the right of his mouth, to the right of his mouth, it looks almost like a nail scratch to me. Whereas this one in the front looks like it could have been done with like glass. But again, that could have been her nails. I don't know. But apparently she had done this to him. I don't know the dates on this. So but I did want to show you guys what I had found. It's, ugh.
I don't have those with me right now.
So you said you don't have them, as in, does that mean that you're not sure if you recorded her before?
Correct.
Okay. So you're not sure if you recorded her before February 27th, 28th, but you're certain that he did afterwards?
Yes.
Just directing the court to State's Exhibit 11 and the court's prior rulings. Sir, you're aware of a series of videos that the state has entered into evidence that was discussed here earlier?
Yes.
I'm not going to kind of publish those in air notes because the court has already had them, but would you just generally describe those 3 videos?
So on one of the videos,
Objection. Raccoon eyes could also be from doing substances too, though. I was thinking about that and not getting enough sleep. Did you know that supposedly they were staying up all night partying and then getting up the next day to work? No, those pictures that I just showed you guys, I don't think they were after he passed. That was like that was when he had gone to the hospital on his own at some point. That's true, DC. Some people have dark circles by genetics, so we could look back at his younger photos. I do have some. and see if he had any raccoon eyes in. When he says hit by phone, I'm thinking a cell phone? That's not that big of a item, heavy of an item.
Okay.
I think they're fixing to pull him off the stand for now and bring him back up later.
Manny. So Detective, as we're talking about, State's Exhibit 11 includes 3 videos and the metadata of 4 videos.
Yes.
Those 3 and another one. Again, the court has State's Exhibit 11, but for purposes of our record, will you just describe generally the 3 videos that were entered in State's Exhibit 11?
So one of the videos, they're in the lobby, and the victim had just explained to her, like, why are you hitting me? You can't be hitting me like that. And then she lowers her voice and tells them, shut the fuck up, bitch. And then he continues to ask her, why are you doing this? Like, calm down. And that was the end of that video. The other video, she was having some sort of tantrum in the apartment and yelling to the top of her lungs. And at one point, she calls out names using the N-word towards the victim. And she also even tells him, come here, let me slap you. And then also continues into telling him, find my phone, get me alcohol, get me alcohol.
During those recordings, did she also express, I guess, a jealousy of anybody?
Yes.
Okay, will you please explain?
She, according to the video, he acknowledged somebody in the lobby or just in front of the building when he went out to I believe it was to walk his dog. And he didn't tell her that he acknowledged somebody downstairs. And then that's when she just went into this continuous screaming for several minutes.
Now that we've discussed that context, I want to talk about building-specific incidents at One Prairie Cell and how they documented these incidents. Did you receive a lengthy amount of records from them?
Yes.
Okay. Do you remember approximately how many pages?
Too many pages.
Too many pages. Okay, fair enough. As part of that, did these reports contain with them photos, videos, audios?
Yes.
These photos and videos, will you describe them to the court how they looked on these reports?
No, I can't remember too much about the
Sure.
those records.
Were these videos and photos and audio recordings, were they original or were they like pictures of videos and things like that?
If I remember correctly, they were original from the actual video.
Okay. And are you referring to a February 21st incident?
Yes.
Okay. Again, that's State's Exhibit 10, I'm directing the court to, but will you please describe it for the court again for our record purposes?
So at one point, the defendant walks downstairs or takes the elevator downstairs. Shortly after, the victim goes downstairs as well. Several minutes later, after that, the victim comes back to the elevator. It opens, it closes. I guess he went to go back to look for the defendant. Eventually, they come back. She enters, then she's trying to click on the on her floor, but she can't because she doesn't have the key fob. So the victim comes in. He's trying to put on the key fob, and she goes into she begins to attack him, pull his hair. She at one point tries to swing at him with the closed fist. So he ends up kind of like holding her down so he can use the key fob and go back upstairs to their respective floor.
Let's parse that through. You mentioned earlier about having received the key fob and directing the court to Exhibit 13. How many key fobs did that apartment have?
2.
Okay. Do you recall which one was Christian's?
Yes.
Okay. Which one was Christian?
Christian's is the one that ends in it's 01027.
And then and that's the serial number.
Yes.
Okay. What was Courtney's key fob?
It was 01058.
How can you tell which one's key fob was whose?
So the defendant's key fob has been inactive because she lost it, and it's been inactive since as of, I believe it was March.
So
and
February 21st, she still had it.
Yes.
Imagine
How
that.
did she lost it. Was that a message?
It was in some of the messages.
Okay. So both Christian and Courtney had key fobs.
Yes.
And so she lost it, you said March 20?
Yes.
Or rather March of 2022. Jesus, I'm losing myself.
March of 2022.
And so February 21st, 2022, she still had the phone.
Correct.
Let's walk through that video. When she enters the elevator right before Christian does, is she holding the door or is she trying to close the door?
She's trying to close the door.
Okay. At any point, does she put her hand over the door?
Just before he made it.
Okay. So she had her hand over the door right before he entered.
Yeah, right before he entered, she put her hand through the door, or on the side of the door, so it can stay open as he walks in.
Okay. And you did go to this apartment.
Yes.
So that door has the sensor.
Correct.
In the video, you said that you can see her tapping the screen.
Yes.
Did you, again, having been in the apartment, you saw how that system is set up?
Yes.
Are you familiar with it?
Yes.
Okay. So her tapping the button, would that have achieved anything?
No.
Okay. Why not?
Because you need to scan the key fob first in order to be able to go to your floor.
So then you said that Christian walked into the elevator and kind of told her to stop banging.
Yes.
What did he do then?
He was trying to tell her to stop. She begins to swing at him and and pulling his hair. So then he kind of like pushes her to the side to try and use the key fob. She continues to jump on him to attack him some more. So at which point he kind of like just holds her down, like bends her over and holds her down so he can finally hit the key fob and click on the right floor.
At any point in time, did Christian exercise, I guess, affirmative violence towards the defendant?
No, he's just more trying to like keep her away from hitting him while he gets upstairs.
Now, date of incident, you received the surveillance video too from the building.
Yes.
Besides capturing Christian leaving, returning, and so on, did the surveillance video from the building capture anything?
I'm sorry, say that one more time.
Besides capturing Christian leaving and then returning, did the surveillance video capture anything about this incident, any violence or anything else?
No.
1 second.
I want to show you guys something really quick. This is from my first documentary I did on this. And I want you to watch her hand as she enters the elevator. This is what he's talking about. Now, mom claims that she was trying to keep him from entering the elevator to go up to her unit with her. Look how her hand's holding the elevator for him. She can't go anywhere, though, because she doesn't have a key fob, and she knows he's the only one that has a key fob. So that whole argument about her trying to keep him from coming up to the room, which has been a big argument of theirs, is blasphemy. It's just not right. It's incorrect. He did act like he antagonized her a little bit, though, you know? Is he laughing or is he just... I don't think he's laughing. He's definitely not laughing there. And then they go into their apartment. The blows, exactly, Patty. The way that she moves, the way that she slaps at him and stuff. That's what I was thinking. Like, if you think about her, if she had a weapon in her hand, the way that she's hitting him. Hang on. I'll do this. Let's watch that one more time. If she had a weapon in her hand, watch how she goes up with her arm and goes down at him. See? It's like always grabbing at his head. She's not aiming to hit him in the stomach or on the... She's always aiming for his head. I'm going to show you guys one more thing, too, before we get off of here. I'm going to show you this picture. If you look at... This was... I think these were done in Aspen, okay? And she had injuries on her while she was doing her photo shoot. Look at her. Look at her arm. The bruises on it. There's nothing that says that she didn't cause that to herself. But there's also no, I mean, there's no proof that, you know, he didn't do it to her. Is that a bruise on her chest? Let me show y'all one more thing. And see this one, she's got a Band-Aid on her fingers. And a bruise on her shoulder. I don't know if that's bruises down her arm or if that's just the contour of her muscles, but yeah, she's all beat up. And it's just like the Sarah Boone thing. I look at that and I think, I swear I feel like she did it to herself. Like it wasn't, like, I don't know. I could be wrong though. I don't want to say that that's what it was, but
Your Honor, there's some testimony that I would elicit that pertains to phase 2. I guess my question would be whether the court wants me to go into that now or wait. Sure. At some point in time, we mentioned how the initial impression, date of incident, was that it was a possible self-defense. And for the last 45 minutes or so, we've been discussing all the subsequent investigative steps.
Yes.
Did these subsequent investigative steps change your outlook of this case?
Yes.
Okay. How did it change?
It changed the fact that I learned that Christian was always the one trying to calm the situation down. Based off of the messages and everything, he was always the one that ends up getting hurt. And the defendant is just the one that's always unable to control herself and hurt him.
As a result, did you apply for an arrest warrant?
Yes.
Was that?
Yes.
Directing the court to state exhibit 1. As a result of that arrest warrant, were efforts taken to locate Miss Clenney? Excuse me.
Yes.
Who assisted in locating Miss Clenney?
The marshals.
Okay. Why were the United States Marshals asked to locate Miss Clenney?
Because she was out of our jurisdiction.
Okay. Where was she?
In Hawaii.
Okay. Do you remember where in Hawaii?
Hilo, Hawaii.
Okay. Did as a result of her arrest, did you travel?
Yes.
To Hawaii?
Yes.
How long did it take you to travel?
It took me about 24 hours to get there.
Okay. How many flights?
3.
And actually, before we go too far down drift, when you received the One Bariso lease records, did you receive a letter documenting the defendant's move out?
Say that again?
Did you, within that packet, was there documentation about the defendant moving out of the apartment?
Yes, they were in the process of
Okay. Did the records document that she moved out April 28th?
I don't remember.
I'll just direct the court to the exhibit for the record 28th. So the defendant had moved out of Miami, was located in Hawaii. Because she was in Hawaii, actually, let me back that up. Do you know how she was located in Hawaii?
No, not really.
So she was located in Hawaii, was apprehended in Hawaii and extradited to Miami. Did you, I guess, as a result of this investigation, were there subpoenas that were prepared obtaining the defendant's financial records?
Yes.
Okay. Let's discuss those financial records. Have you reviewed them?
Yes.
Okay. Directing the court to the financial records, which I believe are states exhibits 29, 30, and 31. Did you at any point in time get a chance to review those records?
Yes.
Approximately how much, and then states exhibit 32 is Bank of America records. Did you get a chance to review those?
Yes.
During that time, immediately before the murder, approximately how much money did the defendant have in her bank account?
I believe she had just over $2 million.
Again, just to direct the court to the exhibits, but roughly. At any point in time after the homicide of Christian, did the defendant make transfers of that money?
Yes.
Okay. Please tell the court.
She made 2 separate money transfers over to her father's.
And that was 9 days later?
Yes.
Did she make any other transfers after that, if you recall?
I don't recall.
There's the lawyer money right there, you guys.
Besides those large wire transfers, when we discussed briefly earlier, we discussed the defendant's criminal history.
Yes.
Will you please tell the court the defendant's criminal history and directing the court to exhibit 20?
Well, she has the battery out of Las Vegas.
Okay.
And then she has DUIs out of Texas. And then I believe also out of California.
Did the defendant, so let's talk this through, right? So she has a 2015 DUI from Texas. And then you said it's something from California.
Yes.
Was the California case, did she pick up that case while the DUI was pending, the first one?
Yes.
And then you said she had a second DUI in Texas, and then for the record, it's September 16th in 25. Did she pick up the domestic violence battery in Las Vegas while that case was pending?
Yes.
Do you know if 2020 DUI is still pending in Texas?
I believe so.
And do you know if the defendant has a warrant for that case?
Yes.
One second.
So it was a DUI in California. I was thinking it was some kind of domestic, like some kind of battery or.
And just to finish up, the wire transfers from from the defendant's account to her father. Did that essentially deplete her bank account?
Mostly, yeah. She just left some money for herself.
Stay on to the question.
Okay, so they're going on break now. So what we're going to do is we're going to pick up and watch the rest of this on Thursday. How about that, you guys? Just the rest of that day, because they still have another day worth of hearings, but we've got plenty of time, so I'm not in any hurry. So she gets a DUI in Texas and another one in California. To me, anybody that has 2 DUIs, that's a red flag for somebody that has a problem with alcohol. Wouldn't you think? I don't know. I don't want to judge anybody about that, but it just seems like one would keep you from ever doing it again. It would scare the bejesus out of you, cause enough problems to where you would just never do it again. Also goes towards why she's never driving. But, look at this, y'all. Look at this picture. Now, this could have just been a photo they took just to take a picture. It may not be that she was actually driving, but. I don't know when that was taken. It could have been in Miami, but they've got a couple pictures with that Lamborghini. I don't think it belonged to them. I'm sure it was rented for photos. I bet they rented a lot of stuff just to take photos with it. Well, I guess that's part of that big business. Okay, the other thing I want to talk to you guys about is what her attorneys had said. Let's go to that. This is coming from him. He said, Courtney was failed by the system as a woman seeking help from an abusive and violent relationship. The evidence is a one-sided snapshot in time. It's not the whole story. It's missing context. The most sensational pieces of evidence are being cherry-picked by the reporters without proper context to feed the public's curiosity with this case. The charging decision in this matter should have been made on the evidence of what occurred that evening in the apartment and nothing more. This is a case of self-defense, and the facts that will be presented at trial will prove this. Also, the majority of the records released so far have come from Christian's cell phone. There is another side to this, and we look forward to presenting it in court. Now, we were talking a little bit about her ex-boyfriend, that we know that she broke his jaw. This little article right here says that I guess she was in a relationship with him. His name, excuse me, his name is Sean Roden. Roden. He is one of the ex Mr. Olympias. and she was dating him at some point. This was when she was in California. And she didn't know he was married, and I guess when she found out he was married, she cocked him with her fist and broke his jaw. So, I'm sorry, I don't mean to laugh at that, but, you know, he didn't tell her he was married. But anyway, so that's the story that's been going around. This is the clip that I got the source from. I'm assuming this is true, but again, I would love to see this guy come on the stand and talk about his relationship with her and how she reacted. They have got to bring some ex-boyfriends to the table, you guys. They've got to. They now the hard part's going to be finding them because the parents are not going to help them find ex-boyfriends. But the prosecution does need to definitely bring that in. You know what I mean? You know? I hope so, Michelle. I hope they do bring at least one. Um, Jane says the media is ignoring the fact that Christian had, wait, I just lost digital wealth on his computer that they hacked. Digital wealth? You're talking about the Bitcoin stuff? What do you mean by that? Digital wealth? Because he didn't really have a lot of money. I mean, and she was his so-called manager, I guess. I saw that in one of the, I guess that's what the TMZ, yeah, the TMZ mentioned that. And that one girl that was talking about them, the one that was on Instagram, what was the other thing she said? She said her manager had said to her, he was kind of prepping her for the gig because it was one of those trips where they all get together and go do shoots and stuff. And he's like, "Look, the one of the girls that's going to be there, I'm going to warn you about her." And it was Courtney. And he said she takes drugs, she drinks a lot, and she gets crazy. And well, I don't know if he said she gets wild. And you need to get out, do what you need to do, and then don't really spend a whole lot of time with her. Stay away from her. Stay out of trouble. So that was interesting. At least that's what she said. He had a ton of Bitcoin and cryptocurrency. Okay, Jane, thank you. So we know they're probably going to bring some of these OnlyFans models to the stand, but I think there's going to be a credibility issue with them, because of what they do. And I'm not saying that from my judgment factor. I'm just saying it's going to be a problem. It's like bringing in somebody that is in jail almost. Maybe not as bad. Or bringing in somebody that is a prostitute or something. Their character is going to be criticized. You think they were trying to get to his millions through the PC, through the laptop? See, I think that they were trying to get any kind of damning evidence against her, because I also believe that if he was working for her, uh, and this was the other question mark that I had on it all. If that you could say that that was his laptop and they both used it, but if he's working for her and he uses that in his form of work with her, then how does that not become part of her property as well? Do you know what I mean? So I kind of wonder about that. Wait, 2 of her ex-boyfriends have passed away? What? Michelle, where'd you get that from? Oh, Roden died in 2021. I did not know that. What'd he die of? Heart attack at 46 old. Yeah, I was thinking that too when you said that, steroids. Well, dang. I did not know that. Well, I guess he won't be on the stand. I'm hoping they'll find somebody they can pull up on the stand, though, you guys, an ex-boyfriend that had relationships with her. Somebody that she had a close relationship with that she went off on. So anyway, I guess that's going to do it for tonight. I really appreciate you guys being here with me and kind of like watching this, if you've already seen it, kind of give you a good refresher. And then if you haven't seen it, then you're kind of learning it as with me as we go. I'm going to take some of these clips and make some smaller videos out of them and put those up as well. And I definitely want to go through the timeline in a future video to like pinpoint when they started fighting, when these fightings were documented, when each one happened, because we've got so much video footage and audio footage of their different entanglements and stuff. So we'll get that. And but let's get caught up on these hearings, because there's only, from what I saw, there's only like 3 or 4 of them. So we could get caught up on that, and then we can go back and look at the other stuff, because they're going to continue to have future hearings, and we want to be in the mix. We want to be in the know, I guess. Him being famous makes it hard for me to believe she didn't know he was married, Veronica said. I guess that's a good point. I guess that's a good point. How long were they together? I mean, you know, that was the thing. Like, if they had been together for a good time and she was really into him, yeah. I mean, who doesn't look that stuff up? Who doesn't? Kind of trying to find a little background. These days you need to. But I believe that somebody in that bodybuilding world, Patty, was one of her links to the OnlyFans world. I do. I think that it just kind of one thing led to another, and she realized she could just make a whole lot more money doing the OnlyFans. To each his own. Alrighty. Well, that being said, I guess I will see y'all on Thursday. Thanks for being here. We'll get even deeper into this in the very near future. And until then, y'all be safe. Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.